Welcome, everyone. We're doing a deep dive today into the 1924 Turkish constitution.
That's right, using materials from Turkish law talks.
Our goal really is just to unpack its foundational principles, the structure, and some key aspects.
It's a really important historical document.
Definitely. And if anything we discuss sparks a question, just leave a comment below the video.
Yeah, we'd love to hear from you.
Okay, let's jump right in with our source material, starting on page 1.
Okay, page 1. So the 1924 Constitution, it clearly builds on the state system principles from the 1921 Constitution. There's continuity there.
Right, it's not starting from scratch.
Not at all. And Article 1, I mean, this really jumps out. The state of Turkey is a republic. Come hurryet.
A foundational statement.
Absolutely. And what's key, like really key for you to note, is Article 102. It makes that statement unamendable.
Unamendable, wow. So this wasn't just like a guideline.
No, it was the absolute bedrock, right from the start.
Okay, and this idea of a republic, it connects back, doesn't it? Article 3 talks about national sovereignty, milli hegemonlik.
Exactly. And the source points out this concept was already there in the 1921 Constitution.
So it's a deliberate carryover. They're reinforcing this idea about where power truly lies.
That's a crucial point. Now, the first page also mentions something interesting. Initially, there was a provision stating Islam as the religion of the state.
Oh, right. But that didn't stick around.
No, it didn't. And this is where it gets quite significant for understanding the period. That provision was actually removed in 1928.
Okay, a few years later.
And then if you go forward to 1937, you see the principle of laicism, laiklik, being added.
Alongside the other added Turk principles.
Precisely. So this evolution, it tells you a lot about the early republic's direction, you know, the debates shaping its identity.
Fascinating stuff. Okay, let's turn the page. Page 2, the legislative body.
Right. The Grand National Assembly of Turkey, Turkey, Büyük Millet Meclisi. The source describes it as unicameral.
Meaning a single chamber.
Yep, just one house, composed of deputies, mebus or milletvekili, elected by a special law. But look at the original rules for who could vote.
Article 10. Initially, only males, 18 and over.
Correct. And eligibility to be elected? Article 11 set that at 30 years old minimum.
So those initial criteria really defined who had a direct say back then.
They absolutely did. But then came a huge change, a really transformative one, with the 1934 amendment.
What happened then?
Well, interestingly, the voting age was raised slightly to 22, but the massive shift.
Women's suffrage.
Exactly. Women gained the right both to vote and to be elected, 1934.
That's quite early, historically speaking, compared to many places. A huge step.
A watershed moment, absolutely. Put Turkey ahead of many Western nations at the time on this issue.
The text also notes elections were every 4 years, with re-election possible.
Yes, standard 4-year terms, deputies could run again. And Article 13 makes a really important point about representation. That the deputies represented the entire nation, not just, their local constituency.
So speaking for Turkey as a whole, it points towards national unity.
Precisely, it underscores that idea. And one more thing on this page, Article 17, legislative immunity.
Meaning they couldn't be prosecuted for things said or done as part of their job?
Essentially, yes. Legislative immunity and non-liability. It's a common feature designed to protect legislative independence.
Got it. Okay, so page 3 dives into the actual duties and powers of this assembly, the GNET.
Right, and the list is quite extensive. First up, it mentions implementing religious provisions, ahkam şer'iye.
Which ties back to what we said earlier about the initial role of Islam before the later changes.
Exactly. It reflects that specific historical context, that transitional phase. But beyond that, you have the core legislative functions.
Like enacting laws, amending them, repealing them.
Interpreting them, too. The whole legislative life cycle.
Makes sense. And then big foreign policy powers. Making treaties, peace agreements, declaring war.
Yes. All the major decisions regarding international relations and national security rested with the assembly.
And what about money?
Crucial financial control. Adopting budgets, final accounts, deciding on printing money.
And approving or rejecting big contracts like monopolies or concessions.
Exactly. Controlling the nation's purse strings, ultimately.
And finally, powers related to justice. Amnesty, changing penalties, death sentences.
Yes, declaring general and special amnesties, reducing or changing sentences, deferring legal actions, and even the final decision on executing death sentences that had been finalized by the courts.
Wow, that's a very broad range of powers vested right there in the assembly.
Oh.
So let's look at the executive then, page 4.
And Article 5 here is really, really insightful about the initial setup. It says, legislative authority and executive power are manifested and centered in the Grand National Assembly.
Centered in the assembly, so not really a separate executive branch initially.
It highlights that concentration of power, yes. It wasn't the strict separation we often think of. The assembly was dominant.
Yeah. Okay, so a very concentrated system. But Articles 6 and 7 sort of explain how it worked in practice.
They do. Article 6 is clear. The GNAT exercises legislative power directly. It makes the laws.
And Article 7?
Article 7 says it exercises executive power through two key figures, or bodies rather. The president, who is elected by the GNAT.
Elected by the assembly itself.
Yes, and the Council of Ministers, Acri Vicilari Hayeti, who are appointed by the president.
Okay, so the ultimate power is with the assembly, but it delegates the day-to-day execution.
That's a good way to put it. Let's explore the president's role more. Page 5.
Right, so the president wasn't directly elected by the people.
No, elected by the GNAT General Assembly, specifically from among its own members.
And for a 4-year term, tied to the assembly's term unless there was an early election.
Correct, and Article 31 explicitly allowed for re-election.
This election by the assembly, it really cements that link between the legislative and executive, doesn't it?
It absolutely does in this initial structure. And Article 33 handled vacancies. If the president couldn't serve, temporarily or permanently,
Who stepped in?
the Speaker of the Assembly became the acting president.
Interesting. Okay, let's look at the president's actual powers and duties on page 6.
All right, so as head of state and part of the executive structure, the president had several key jobs. One was promulgating laws.
Meaning signing them into effect.
Yes, within 10 days. Or the president could send them back to the assembly for reconsideration.
But there were exceptions.
Right. The text notes this didn't apply to constitutional amendments or budget laws. They had their own process. That's an important detail.
Good point. And appointing the government.
Yes. The president appointed the prime minister, who had to be an assembly member. Then the PM would choose the other ministers.
Also from the assembly.
Yes, according to Article 44, the PM chose them, and the president then formally appointed them.
And foreign affairs. Receiving ambassadors, that sort of thing.
That fell to the president, too. Article 37, sending and receiving foreign representatives. Standard head of state stuff.
And Article 42 mentions pardons.
Yes, the power to grant pardons or commute sentences, but specifically for reasons like disability or old age, a sort of humanitarian consideration.
Okay. And Article 40, representing the supreme command.
Right, which the Constitution stated was embodied in the GNAT. So the president acts as the figurehead for that command authority, linking the executive back to the assembly's ultimate power, especially regarding the military.
Okay, now page 7 talks about responsibility, or rather irresponsibility. This sounds important for understanding checks and balances.
It really is. It discusses the president's political irresponsibility. Article 39 says executive acts needed the signatures of the prime minister and the relevant minister.
Meaning the president wasn't politically on the hook alone for decisions.
Exactly. The president was shielded politically. And the direct consequence, laid out in Article 46, was that the prime minister and the minister involved were responsible.
Responsible to whom?
To the assembly. This is classic parliamentary procedure ministerial responsibility.
Right. What about criminal responsibility? Could the president be charged with crimes?
For official duties, Article 41, Section 1 says no criminal responsibility except for one thing: high treason. Vatan Henley.
High treason only. That's a very high bar.
It is. But Section 2 of Article 41 clarifies that for personal crimes, things unrelated to official duties, the president was responsible like anyone else.
But would parliamentary immunity apply then?
Yes. The same immunity provisions we discussed for deputies, Article 17, would apply to the president in cases of personal crimes. It's an important distinction, official versus personal acts.
Okay, that clarifies things. Let's move to page 8. The Council of Ministers, the actual government.
Right. The Constitution really positions the Council of Ministers as the main authorized and responsible executive body, the engine room, you might say.
And formation starts with the president appointing the prime minister?
From assembly members, yes. Then the PM selects the other ministers.
Also from the assembly.
Submits the list to the president for approval, and once approved, the government is formed.
But that wasn't the final step, was it? Article 44 again.
Correct. Within a week, the new government had to go before the assembly, present its program, and crucially, seek a vote of confidence.
So the assembly had an immediate check. They could essentially veto the government right at the start.
Precisely. It highlights the assembly's power, and the Constitution also embedded the principle of collective responsibility.
Meaning the whole government was responsible for general policy?
Yes, the Council of Ministers as a whole, but also each individual minister was responsible for their own ministry's affairs and actions.
A dual responsibility.
Exactly. Both collective and individual. It's very characteristic of parliamentary systems.
So the source concludes here that both the president and the Council of Ministers were set up very much along the lines of a classical parliamentary regime.
That's the takeaway, yes, despite the assembly's overall power concentration. Now, should we shift to the judiciary? Page 9.
Yes, let's look at the judicial power. Kuvai kazaye. What were the key principles here?
Well, first, Article 53 says the organization, duties, powers of the courts, all that was to be regulated by law. So the legislature defined the judicial structure.
Okay. And judicial independence.
Article 54, Section 1, explicitly states judges are independent, free from any interference. That's fundamental.
How is that protected?
Well, the Constitution said neither the GNAT nor the Council of Ministers could change, delay, or stop court decisions. And Article 55 added that judges couldn't be dismissed except under specific conditions laid out in law.
Job security, essentially.
Aiming for security of tenure, yes. Let's continue that on page 10.
Okay, page 10.
Uh-huh.
Article 56 says the personal rights of judges and the conditions for their removal were set by a special law. Again, legislative involvement.
Yes. And Article 57 aimed to prevent conflicts of interest. Judges couldn't hold other public or private jobs unless legally specified.
Transparency, too. Article 58.
Right. Trials were to be public. And Article 59 guaranteed the right to use legitimate means to defend oneself in court. Due process.
And Article 60, courts couldn't refuse cases.
No, they had to hear cases within their jurisdiction. Now, despite all these principles,
There's a critique.
yes, the source offers a critical view. It argues that while these provisions aimed at independence, the guarantees weren't very strong.
Why not?
Because too much, like the detailed regulations, was left up to the legislature's discretion, and perhaps more significantly.
No constitutional court.
Exactly. There was no dedicated court to review if laws passed by the GNAT actually violated the Constitution, nor could ordinary courts do this review.
So who checked if laws were constitutional?
Well, complicating things further, the power to interpret laws was given to the GNAT itself, the legislature, not the judiciary.
So the body making the laws also had the final say on what they meant and whether they fit the Constitution.
That's the implication. These points are crucial for assessing the actual separation of powers. Okay, let's step back and look at the overall system of government described on page 11.
Right. The source calls it a mixed system. Parliamentary and assembly government, Meclisi hükümeti. What are the assembly government parts?
Well, first, Article 4. The GNAT is the sole and true representative of the nation, exercising sovereignty alone. That really centers power in the assembly.
Okay, dominance of the legislature.
Second, Article 5, which we mentioned, legislative and executive power are manifested and gathered in the GNAT. Unity of power, essentially.
Power concentrated there.
And third, Article 7 gave the GNAT power to supervise and dismiss the government anytime. But the government couldn't dissolve the assembly.
An imbalance of power. That sounds very assembly government.
It does. But let's look at the parliamentary aspects on page 12.
Okay, so despite that concentration, there were parliamentary features.
Yes. Even though the assembly held ultimate power, Article 7 said executive power was exercised through the president and council of ministers. Distinct executive roles existed.
Right, the practical functioning.
And the whole government formation process we discussed, president appoints PM from assembly, PM picks ministers from assembly, president approves, vote of confidence needed.
That sounds very parliamentary.
It's textbook parliamentary procedure. And finally, the explicit adoption of collective responsibility for the government's policies. That's a core parliamentary idea.
So it's a blend. What's the term the source uses?
Doctrinally, it's often called unity of powers and separation of functions. Kuvvetler birliği ve görevler ayrılığı.
Unity of powers,
Yeah.
but separation of functions.
Yeah.
Okay, it tries to capture that mixed power centered in the GNAT, but distinct legislative and executive roles in practice.
Exactly. It's a way to frame this unique structure. Now, shall we look at fundamental rights and freedoms, page 13?
Yes, public rights of Turks, Türklerin kamu haklarını. Fifth section. What does Turk mean here?
Good question. The source clarifies it's not ethnic. It's geographical people of Turkey and political citizens of Turkey. An inclusive definition.
Okay, important distinction. And the philosophical basis.
Liberal, individualist natural rights doctrine, belief in inherent individual liberties.
But how were these rights actually handled in the Constitution? Page 14.
Well, despite that liberal philosophy, the regulation was, well, not very detailed. It mostly listed rights, but then added a general clause
What was?
that they could be restricted by law, so the rights weren't absolute.
And the thinking behind that, why not spell them out more strongly?
The presumption seems to have been that since the GNAT represented the people's will, any laws it passed restricting rights would inherently be legitimate and sufficient protection. Trust in the legislature.
So what kind of rights were included?
Mostly the classical civil and political rights, freedom of speech, press, assembly, that sort of thing.
What about social rights,
Yeah.
like healthcare, welfare?
Very limited, according to the source. The only specific social right mention is compulsory primary education in state schools being free.
So the focus was much more on individual liberties against the state, rather than social provisions.
That seems to be the case in the initial formulation. Okay, final topic. Page 15, the Constitution's own status, supremacy and rigidity.
Right. Article 103, constitutional supremacy.
Absolutely explicit. No article could be ignored or suspended, and crucially, no law could contradict the Constitution. Foundational principle.
And it was a rigid constitution, meaning hard to change.
Yes, Katu. The amendment process in Article 102 was tougher than passing regular laws. Needed a proposal signed by at least 1/3 of members.
And then acceptance
A
bond.
supermajority, at
Yeah.
least 2/3 of all members. A high threshold.
And was anything completely off limits for amendment?
Yes, one thing. Article 1, the statement that the state is a republic, there was an absolute ban on even proposing an amendment to change that.
Wow. So the Republican form of government was untouchable.
Absolutely cemented as the unchangeable foundation.
Okay. So, to kind of wrap this up, the 1924 Constitution set up a republic, emphasized national sovereignty in the assembly, used this mixed unity of powers, separation of functions government model.
Right, blending assembly and parliamentary features. It included liberal rights, but allowed legal restrictions and didn't detail social rights much initially.
And it declared itself supreme and made itself hard to change, especially the part about being a republic.
Exactly. Understanding these core elements really gives you a solid framework for grasping the early Turkish republic's legal and political structure.
It certainly does. Well, that brings us to the end of this particular deep dive into the 1924 Constitution. We really hope this breakdown was helpful for you.
Yeah, I hope it provided some clarity on this foundational document.
If you do have more questions or thoughts, please do share them in the comments section below.
We appreciate the engagement.
And please don't forget to subscribe to the Turkish Law Talks YouTube channel. And give this video a like if you found it useful.
It helps support the channel.
We look forward to exploring more legal topics with you in our next lesson. Thanks for joining us.